Hello, welcome to this video on loss of control, another defence to murder under the voluntary manslaughter handle. So, a quick overview of this defence. We're going to discuss when this can be used, we're going to discuss the definition of the defence, and of course the elements. For those of you who studied law for some time, this will be of no surprise to you at all. So our aims and objectives to drill down a little bit more. So we aim to develop knowledge to partial defence by looking at defining loss control, explain the elements, and of course develop to use legal authority to support each point and to learn how to apply the law to problem questions. Now some quick exam hints then with respect to loss control. We are never in any exam going to apply the loss of self-control to any other crime other than murder. This is a special defence in that this is only available to an offence of murder. This is one of the most common mistakes by students who apply the law, so we need to make sure we avoid doing this. Now, voluntary manslaughter itself in an exam is nearly always going to be combined with a question on murder within the exam due to the nature of these partial defences. So we always need to prove murder first and then raise defence, and this is because, of course, diminished responsibility and loss control are not offences, but they are defences to murder. But with respect to loss of control specifically, we can usually identify the partial defence which may be used through the language. So for example, the defendant lost control, the defendant flew into a rage, or had temper, for example. Now we do need to be aware for information purposes that this defence of loss of control it developed from the law on provocation, which was under Section 3 of the Homicide Act of 1957. And most case law we're going to see is based under the old law of provocation. Now we still use them to prove certain elements. There are one or two changes, and we'll make these clear as we go through. But one key change is that the loss of control no longer has to be sudden. Now, of course, the loss of control itself as a defence is a matter for the jury. But the defence must firstly raise the defence through sufficient evidence. Now, the defence can be rejected by a judge, but if the judge decides it's able to be put before the jury, then the prosecution have the burden to disprove the defence beyond reasonable doubt. So quite a high bar. But one argument might be for this is that, of course, not many people are going to kill if they've not lost control. Usually you'll see a situation where there is a degree of anger. So, of course, that might be one argument, but we do need to be aware that it's on the prosecution to disprove it, and so you must reflect that in your applications. So we now use the definition from the Coroners and Justice Act for loss of control. So Section 54, subsection 1 tells us where a person, the defendant, kills or is party to a killing of another, the victim, the defendant is not to be convicted of murder if the defendant's acts and omissions in doing or being party to a killing resulted from the defendant's loss of self-control. This loss of control had a qualifying trigger, and a person of the defendant's sex and age with a normal degree of tolerance and self-restraint, and in the circumstances of the defendant, might have reacted in the same or similar way to the defendant. So what we're going to see is this is our definition, and we need to be careful. We need to make sure we use the sections of the Act. In essence, there are interpretation sections in this particular Act which tells us what each of those means. So what 54.1a means, what 54.1b means, and what 54.1c means. And we need to be absolutely clear in our exam as to what these mean. So to break it down, what we've got is we need to look at loss of control. We need to consider, was there a qualifying trigger? And then we need the objective test. We need to consider would a person reacted in the same way. What you'll notice here though as well is I've put in restrictions from section 55.6. And the reason I put this in is because a lot of students from my experience will do the loss control, will do the law qualifying trigger, and will consider the objective test, but will not consider any restrictions. So I made it abundantly clear here, as we go through, you should consider each one. So as ever, we're going to start from the beginning. So section 54, subsection 2 of the Act tells us what a loss control is. So we're about to explore this, what it means, and look at cases and how it's been decided in cases. So of course, the loss of control, the important thing here is it's a subjective test. So the defendant must have lost control, and they must demonstrate with their evidence that he or she was so strongly affected by the qualifying trigger they've lost control. So they must have lost total self-control when doing the act which caused the death. Now, of course, the jury who are deciding this can draw on their own life experience to decide whether this was the case. Now, ostensibly it's a subjective test, but the jury will inevitably be considering their own viewpoints, and it sort of is some hybrid between subjective and objective to an extent. Now, the loss of self-control will normally be because of things said or done by the victim to the defendant, but it doesn't always have to be so. Now, in terms of what is loss control, we need to give an explanation, don't we, in an application for the explanation of the law. Now, in Duel from 2014, which was challenged and rejected in Gurpinar in 2015, they adopted the Smith and Hogan textbook definition. So Smith and Hogan define loss of control as the defendant lost his ability to maintain his actions in accordance with considered judgment, or he's lost normal powers of reasoning. Now that's a definition, but in reality what it could mean is that the defendant lost his or her ability to maintain his or her action in accordance with considered judgment. So considered judgment means that thinking process. So they're not thinking in a normal way in terms of processes. Or it could mean the defendant lost his or her normal powers of reasoning. So compared to the normal standard, are they able to think clearly? And then finally, the defendant's behaviour was atypical, which means it's not typical, or it's out of character, and normally he or she, so subjectively, would not have acted in this way. So a good example of this is Duel. Now, Duel shot a victim at point blank range. He was arrested in his car, and in his car he had weapons, ammunition, and what was described as a survival kit, which included spare clothes, tent, passport, driver license, and even a checkbook. Now, at his trial, he gave a description. Now, this lifted this description. I did it because I lost control, and so on. Now, the judge considered that there was insufficient evidence of his lost control, because this was not out of character, or this wasn't. It was still a considered judgment, because he clearly planned to escape, so clearly almost planned to do the thing, and that indicates that he didn't lose control. In fact, he seemed to be in control. In Cocker, this person killed his wife when she was unwell, so it was a mercy killing or euthanasia by suffocating her with a pillow. But again, there was no loss control, so he shouldn't have used this defence. I mean, you could argue, I suppose, there's a bit of a crossover. You could perhaps use diminished responsibility, given the nature of this. There perhaps could have been some depression, and you will have looked at cases, and indeed look at the other video on diminished responsibility for some cases which include these type of events. But certainly no loss control in this situation. We can look for Abrams and Gregory. I mean, this was based on the old defence of provocation because the act wasn't sudden. Now, this was a retaliation to bullying from two co-defendants on a third person. They killed him because they were bullying. He was bullying them too, quite severely. They planned to kill him and killed him. Now, there was a pattern of behaviour which perhaps now would satisfy the defence because it doesn't have to be sudden. And again, in Alevelaw, again a case which was decided on the basis of diminished responsibility on appeal, but of course the defence of provocation wasn't allowed because the act wasn't sudden. Again, it's arguable, and indeed one of the main reasons that the law was changed, in that this sudden element is now removed. If there's that slow burn effect, or there's something which now almost a straw that broke the camel's back, if you like to use that phrase, then these kind of events, so domestic abuse in this case, for a number of years, a reaction to that would be a loss of control in these circumstances. Now it's certainly argued. So just to reiterate that point then, so under section 54 subsection 2, the loss of self-control doesn't have to be sudden. So one of the key changes from the old law of provocation, and we just considered Alevelaw, the idea that this would now be possibly decided differently than under the old law. So once we've established that under section 54.2 there is a loss of control, which doesn't need to be sudden. We need to think of the thing said or done. Was it a qualifying trigger? So qualifying trigger means almost that there is a justifiable reason for the defendant doing what they did. So qualifying trigger is split into two potential triggers. We have what is called a fear trigger, or commonly known as an anger trigger. We can indeed have a combination of the two. So qualifying trigger, as we say, the defendant's fear of serious violence from the victim against the defendant or another identified person. Now this is a subjective. Do they genuinely fear serious violence? So it is a subjective test there. Or does the defendant's loss control, is it attributed to a thing said or done by the victim which constituted circumstances of an extremely grave character and caused the defendant to have a justifiable sense of being seriously wronged? And as we said, these are commonly known as the fear trigger and anger triggers, and are legislated for under section 55 subsection 3 and section 55 subsection 4 of the Coroners and Justice Act 2009. Now they are normally done by the victim, so the victim normally does something which causes the reaction, but that doesn't always have to be the case. And as ever, we start with the beginning. So we're going to look at the fear trigger first, which is legislated under section 55 subsection 3 of the Act. Now the fear trigger then, under section 55 subsection 3, the defendant must fear serious violence from the victim against him or herself or another identified person. Now violence doesn't actually have to happen, and the test is subjective. If the defendant can show and has enough evidence that he had genuine fear of serious violence, whether or not it was reasonable, then they may be able to use the defence. But of course, it's easy to prove if it's on the person, but this other identified person, there usually needs to be some sort of relationship. Normally, this is going to be something like a child or other relative of defendant, but using serious violence against people in general is probably not going to be sufficient for this defence. Now, under section 55 6a, where a defendant has incited the violence in order to have an excuse to use force, they cannot rely on the qualifying trigger. And this was emphasised in Dawes. In the case of Dawes from 2013, the defendant found his wife with another man, who the defendant, Dawes, then stabbed and killed. It was held in this case the defendant cannot rely on the fear of violence where he or she had induced the violence, where the defendant has the normal capacity of self-restraint and tolerance then, unless the circumstances were extremely grave. Now in this case, the confrontation was initiated by Dawes, so therefore was self-inflicted. So once we dealt with the fear trigger, we next deal with the anger trigger. Now the anger trigger is laid out in section 55 subsection 4 of the Coroners and Justice Act 2009. And what the Act tells us is there are 2 points which have to be proven to show the defendant if they're relying on things said or done as a qualifying trigger. Now these things, the things said or done, were of an extremely grave character. Now extremely grave just means really serious to the defendant. And then the things said or done cause the defendant to have a justifiable sense of being seriously wronged. Now of course, remember, it's the jury making this decision. So we're going to split this into three. We're going to consider what things said or done means. We're going to consider what must constitute circumstances of an extremely grave character means, and indeed look at some case law, and indeed of course the final element, and cause the defendant to have a justifiable sense of being seriously wronged. So the things said or done then cannot include circumstances only. So there needs to be a positive thing said or done, normally to the defendant. Now it doesn't need to come from the victim, so it can come from somebody else, as long as the person loses control. So for example, in Davis, a provocation case, the defendant killed his wife after being provoked by his wife's lover, and this could now be considered as a thing said or done, because of course it's from someone else other than the victim, but they would suffice under the new law. Now extremely grave character just means it's serious to the defendant, so they find it serious. Now in Camplin, a case we're going to discuss quite a lot in this in this video is a situation where a defendant was homosexually raped and then mocked and taunted for being gay by the victim. Now, this, of course, was a thing said of an extremely grave character. It was very serious to the defendant in this case. He was a 15-year-old boy. And in Muhammad, the defendant, who was a devout Muslim, returned from a mosque to find a boy in his daughter's bedroom, and he killed his daughter. Now, this was extremely grave to him. There can be no doubt in that in this case. However, we'll come to whether it satisfies this element next. So the defendant has a justifiable sense of being seriously wronged. This is the third thing that must be proven. Now, whether a defendant's sense of being seriously wronged is justifiable is an objective question for a jury to decide. So in essence, what they're going to do is consider would they have been seriously wronged in that situation, and that's the reality, isn't it? Now, the threshold is quite high to reduce the potential availability of this defence. What this means is, as a result, many cases where the defendant was able to use the former defence of provocation now wouldn't be able to. So, for example, in Doherty, where a crying baby was a thing said or done. So, if we compare two situations with respect to whether a defendant would feel justifiably wronged, we can look to Camplin. And in Camplin, you would imagine, or the jury would imagine in this case, he would feel wronged having been raped and taunted. By Muhammad, not so much. It wasn't justifiable to feel wronged just because a boy was in the room, irrespective of obviously cultural differences there. So this kind of case wouldn't be able to rely upon loss of control. If we look to one of the key changes, we got the case of Doherty from 1989. Now, in this case, the defendant killed his baby son because he wouldn't stop crying. Now, initially, the defendant was able to raise the defence of provocation, which is the old law, which is what loss control is now replaced. His murder conviction was overturned as the judge hadn't directed the jury as to the baby possibly provoking the defendant. There was no question that in this case it wouldn't feel justifiably wronged in this case. Now, the second element would not be satisfied at all. In the case of Zabidi in 2012, so decided under the new law, the defendant killed his father, who was suffering from Alzheimer's and was double incontinent, so he was very frustrated looking after him. But he also claimed he remembered the abuse he suffered as a child and he lost self-control. Now, we don't know what a jury debates. That's the nature of the jury. We don't know what they discuss. But by the fact they rejected this defence and found him guilty of murder, we could probably glean that the jury must have considered this defence and decided that neither of the qualifying triggers was present. So this idea, those circumstances were not extremely serious to the defendant or extremely grave, and there is no question an ordinary person would not feel justifiably wronged on this occasion, so they found him guilty of murder. In Howto, this was a question of whether circumstances are extremely grave. In this case, it was a breakup of a relationship, and that would not normally constitute circumstances of an extremely grave character, nor entitle the aggrieved party to feel justifiably wronged. Okay, it's a breakup, not enough for loss control defence. In Boyer, in this particular case, the defendant killed a love rival in his own home during a burglary. Now, we don't do burglary on the AQA specification, but if you do burglary, you'll understand that if you enter as a trespasser to steal or to do one of another ulterior offences such as GBH, as there was in this case, that is burglary. So he was committing burglary, but of course, when he went into the property, he then killed the victim. Now, the defendant had no justifiable sense of being wronged, given that he was the one committing the burglary at the time of the offence. Now, of course, we can have the fear trigger or we can have the anger trigger in the scenario, but it may also be a combination of the two. If it is, then we should take the time to explore both triggers and apply both of them to a problem question. Now, in some cases, if you're studying this or looking to other materials, then you'll find there are three main elements to loss control. There is a loss control, there's a qualifying trigger, and there's the objective test. But based on my experience of teaching this, some students do forget to include restrictions, which is why I've included this as part of the elements for this defence. Now realistically, in the problem question, one of or more of those will be ripe for discussion, so we should make sure we include it. So to that end, I've included it as an element. So some of those restrictions, 3 of the main ones, which some of we covered already, but because sexual infidelity alone is not to be considered as a basis for the defence. Now, the real issue there is it's actually excluded, but following the case of Clinton, that's changed slightly. So unless then, if disregarding that infidelity, the things said or done by the victim to the defendant still amounts to a grave circumstance, then it could potentially still be a basis for the defence if it's combined with other factors. So for example, if a husband rapes the wife's sister and the wife kills the husband, it's not really the infidelity there, is it? We've also got self-induced loss control or inciting violence. Now if you incite violence, if we use sort of playground talk, if the person started it, who then goes on to kill, then of course we can't use it if you brought about the violence initially. And the final one, considered desire for revenge, is also excluded. So this indicates a planned revenge as opposed to a reaction. So an absolutely key case with respect to changes of the law and restrictions is Clinton from 2012. Now in this case, the facts are relevant in that the defendant and his wife, the victim, were suffering some troubles. They were both depressed, he was suffering stress at work and so on. But they had a separation and they agreed to a trial separation, and she'd come back and told him she'd had affairs, she'd had relations with 5 men, and described them in detail. She didn't want the kids anymore, and also that she was mocking him for visiting and viewing suicide websites. So all of these things would have made him lose control, according to the judge on the appeal, who at first instance it was a murder case. Of course, they rejected because of this sexual infidelity element, but on appeal, that the judge indicated that the defence should have been put to the jury, and a retrial was ordered. So the note here: if other factors count as a qualifying trigger, then the sexual infidelity can be taken into account in assessing whether things said or done amounted to circumstances of an extremely grave character and gave the defendant a justifiable sense of being seriously wronged. So it can be taken into account as part of the whole. Now with loss of control, we sometimes have to look to old cases decided under provocation to compare what the law was and what the law is now. Now Johnson, a provocation case, in this case the defendant's behaviour in making threats to somebody who insulted him led to him to stab somebody, fearing he'd be glassed. Now the murder conviction was overturned, as the judge should have directed the jury as to provocation, but this wouldn't be the position now. This now would be considered inciting the violence and would be a restriction for the defence. So the final restriction we're to look at is revenge. Now the defendant cannot be seeking revenge. If you look to the case of Dawes, as we discussed earlier, seeking revenge will not support the defence. And what section 54(4) tells us is a considered desire for revenge or retaliation will not support the defence of loss control. Now it's important to note that a reaction or retaliation immediately is not necessarily considered desire. What you're looking for there is an element of planning of revenge, or a period of time in which maybe they could stop what they're doing. So in the case of Clinton, it tells us that it was stated the jury will understand the meaning of revenge without further explanation. So it's up to a jury to consider what revenge is. Revenge is clearly outlined in the case of Dryden, where the defendant shot a planning officer who wanted to knock down part of his bungalow because it was built without planning permission. And of course, in this case, it was argued that planned revenge is not enough for a control. There must be an actual loss control, not that planning of revenge. And the final issue we're going to look at is the objective test. So section 54(1)(c) tells us a person of a defendant's age and sex with a normal degree of tolerance and self-restraint and in the same circumstances of a defendant might have reacted in a similar way or the same way as the defendant. So the key question then is, what effect would the qualifying trigger have upon an ordinary and reasonable man? But it's an objective test, and what we're really asking is, was the loss control excusable in the circumstances? But of course, even in the face of a qualifying trigger, the law expects a reasonable man to exercise a certain level of control. So to break that down, we need to consider the age and sex of the defendant and how that can shift from one to the other, and what we expect of a younger person compared to an older person, for example. We then need to consider what is meant by normal amount of self-restraint. Then we consider circumstances and look to case law to consider what should be taken into account. And finally, would a normal objective person react in the same way? And it is of course the jury who make this decision, so we can look to that standard and see what is meant by that. Now, circumstances have been developed through common law. Now, this has always been the case in terms of trying to understand whether somebody would have been provoked. Some of the same tests remain. So if we looked at the case of Camplin, this case introduced a subjective element to the reasonable man test to try to make it a little fair. And so what happened is it was achieved by a two-part test, which is now set out in section 54(1)(c) and 3. Now, in essence, what we're asking is, would a reasonable man of the same age and sex as the defendant be provoked by such conduct? Now, would it make it lose control? And would a reasonable man of all the defendant's circumstances lose control as he did? So the jury can consider the age and sex of a defendant when looking at the level of self-control exercised. As you might imagine, a 15-year-old boy would react differently to a 50-year-old man. So the defendant's conduct is measured against an objective standard, so was the loss of self-control excusable? However, even when subjected to qualifying triggers, they do expect a reasonable man will exercise some control over his actions. So with respect to circumstances, this can get a little confusing, to be totally fair. You can take into account social, religious or cultural circumstances. But the reference in section 54(1)(c) to all the circumstances, other than those who are only relevant to the defendant's conduct, is that they bear on the defendant's general capacity for tolerance and self-restraint. So what we're saying is, would the circumstances impact on the person being able to react or to show control? So this means that the applying a reasonable man test, for example, to a defendant with a short temper is not a relevant characteristic, but if there's history of abuse at the hands of the victim, that would be a relevant characteristic. So the fact that the defendant is particularly hot-tempered is irrelevant. If we look at some key examples, so we've got, these are all sort of cases based on the old law of provocation, but a lot of these we can consider in terms of how the laws decide in a particular way, because there's no real change with this, to be fair. So Newell tells us that only reasonably permanent characteristics should be considered. Mulhall tells us, for example, in this case, glue sniffing was relevant when assessing the gravity of provocation, even when self-induced, but not when assessing the level of self-control displayed. So in fact, wouldn't be able to use. And indeed, intoxication is probably going to remove the defence anyway. In Humphreys, this was a young girl who was immature and she had attention-seeking behaviour, and this was relevant and permanent characteristics, so it could be taken into account as for the objective test. In Asmelash, this tells us that voluntary intoxication is not to be considered as part of the defendant's circumstances, so this is then consistent with diminished responsibility. We got Gregson, and in this case the defendant was unemployed and suffered from depression and epilepsy. All of these were taken to be circumstances. And finally, Hill, who was sexually abused as a child, this was a circumstance which could be considered. We need then to ask, would an objective person react in the same way? So in Clark, it tells us the reasonable man might not have lost self-control because the reasonable man would not have headbutted and strangled and electrocuted his ex-girlfriend. So it's about, would they react in the same way? Of course, most wouldn't. In Van Dongen, the reasonable man might have lost self-control, but the reasonable man would not have repeatedly kicked the victim about his head and body while the victim was curled up in a fetal position. So again, we got lost control, but people wouldn't react in the same way, and that's really the key to that second element. Lesbiani, a woman who was a victim, made a number of anti-Semitic remarks directed at the defendant, who was Jewish, and the defendant took a loaded revolver the victim had provided for target practice, chased after her when she ran away and shot her. Now, the conviction for murder was affirmed by the Court of Appeal because a reasonable man would not have responded so strongly to comparatively little provocation, or indeed the qualifying trigger, if we're applying it to the most recent law. Now, what the following cases in Luke, Thwan, Smith, Holly, and James and Carini, what they seem to do is remove the idea of mental infirmity being a circumstance for the purpose of an objective test. So it's likely then, if there is a circumstance or mental infirmity, the defendant should probably use diminished responsibility instead of loss control. And confirmed by the Attorney General and Holly. So he killed his girlfriend with an axe whilst intoxicated. He admitted to killing with claimed provocation, as we noted before, loss control. Provocation was the defence. And on appeal, the Privy Council disagreed with the case of Smith, Morgan Jones Smith. They suggest the Luke ruling was the correct one, and states that the objective elements of the test should be taken into account age and sex when assessing the ability to exercise self-control, so not any mental infirmity. And that concludes the defence. So what we do is we look through loss control. Was there a loss of control? We consider, was the qualifying trigger a fear trigger or an anger trigger, or a combination of the two. I've added restrictions for reasons I explained earlier on in this video as the third element. And of course, the objective test: would the person react in the same way according to the circumstances and age and sex of the defendant. So we need to do each of these in turn. And once we do, of course, after murder, then we conclude as to whether the defence will be successful or not. And when applying it, of course, we should suggest the outcomes, the idea that it's voluntary manslaughter instead of murder. The sentence is widely varied, but still has a maximum of life rather than mandatory life, and so on. Okay, thanks for watching.